right, good afternoon, everyone. Welcome, welcome, welcome. I'm Angela Onwuachi-Willig. I'm the Dean of Boston University School of Law and the Ryan Roth Gallo Professor of Law. It's a delight to welcome you all here, including those of you who are logged in virtually to our annual Distinguished Lecturer. The Distinguished Lecturer is a BU Law tradition dating back to the 1980s. Previous distinguished lecturers include preeminent legal scholars such as Professors Cass Sunstein, one of your good friends, David Cole, Heather Gerken, Harold Coe, Randall Kennedy, Carol Sanger, Richard Posner, Martha Minow, Melissa Murray, Guy Uriel, Charles, and most recently, Kenneth Mack. In addition to delivering the annual Distinguished Lecture, each speaker's remarks appear in a subsequent edition of the Boston University Law Review. And today it's my great honor to introduce Geoffrey Stone, the Edward H. Levy Distinguished Service Professor of Law at the University of Chicago Law School. Professor Stone will speak about the history of the Warren Court in relation to the Roberts Court. He'll examine key decisions handed down by each of the courts, including Warren Court decisions in Brown versus Board of Education, New York Times versus Sullivan, and Miranda versus Arizona, and Roberts Court opinions in Citizens United versus Federal Elections Commission, District of Columbia versus Heller, Dobbs versus Women's Health Organization, and SFFA versus Harvard College and the University of North Carolina. By drawing out the differences and similarities between the two courts through these opinions, Professor Stone will help us better understand their distinct approaches to interpreting the Constitution. And Professor Stone is well equipped to address this topic. He graduated from the University of Chicago Law School, where he served as the editor-in-chief of the Law Review. And following graduation, he served as a law clerk for Justice William J. Brennan Jr. during the Supreme Court's 1972-1973 term. Thereafter, he returned to his alma mater, joining the incredibly productive and influential faculty at the University of Chicago Law School, and ultimately becoming one of its most impactful faculty members. During his now 50 years as both a teacher and scholar at the University of Chicago, Professor Stone has focused on issues of constitutional law, in particular the First and 14th Amendments. From 1987 to 1993, he served as dean of the law school, and from 1993 to 2002, he served as provost of the university. During his career, he's published more than 15 books and almost 100 scholarly articles on constitutional law. In 2002, he created the Inalienable Rights series for Oxford University Press and has since served as a series editor. The series has produced 25 books by distinguished constitutional scholars, and Professor Stone is also a long-standing editor of the Supreme Court Review. But before we bring Professor Stone to the podium, Professor Jack Beermann, has a special introduction for Professor Stone.
Thanks, Angela. So I'm using my privilege as the chair of the workshop committee and the person who invited Professor Stone to speak to give also a brief introduction. As Angela said, Jeff is the Edward H. Levy Distinguished Service Professor at the University of Chicago, and I had the privilege of taking classes with both Edward H. Levy and with Jeff Stone, and Levy was a superstar, and Jeff has become even more so, so it's fitting that he has that title. If you don't know about Edward Levy, he cleaned up the Justice Department after the Watergate scandal as Attorney General. And Jeff has written more books and articles than I've read in my life. And he's the leading authority in the United States, maybe in the world. I'd have to do some research on that. But he's the leading authority in the United States on the preservation of liberty in perilous times like wartime. And if you only have time to read one of his books, I suggest Perilous Times, Free Speech in Wartime, from the Sedition Act of 1798 to the War on Terrorism, which was written in the wake of the terrorist attacks of 2001 and the government's response. But more important to me back in the early 1980s was that Jeff is a master teacher. He was a bit surprised when I reminded him last night of the 4 testimonial risks that he structured our evidence course around back in 1981 or 82. And my father, who's been practicing law in Chicago for 65 years, says that a continuing legal education lecture that Jeff gave is the best lecture he's ever heard in his life. And it's been a long life. So even more important for me is that Jeff is modeled the way a law professor should treat their students, both in the classroom and in their outside of the classroom ambitions. he really supported me in my quest to become a teacher and scholar of law. He counseled me about the market, and later he invited me to publish in the Supreme Court Review, which was a very prestigious journal. And he really provided the model for the human side of being a law teacher. When I was there, the UC faculty was, very small, and it consisted of people with enormous intellects, and the best way to say is quirky personalities sort of predominated. Would that be a good? But Jeff had the former without the latter, and he treated us with humanity and encouraged us all to do our best. And I'm really proud to consider him as a mentor, and even prouder to have him here at BU Law at my invitation for our annual Distinguished Lecture. So take it away, Jeff. Thank you. I look forward to it.
Let's see here. All these mechanical stuff. Thank you both. Those were lovely introductions. I can't possibly live up to what you just heard, but I'll try. So thanks, Jack, for inviting me. I'm honored to be giving this talk, and I'll begin by briefly discussing 4 important Warren Court decisions and then 4 important Roberts Court's decisions. My point is that these decisions are representative of the quite distinct approaches to constitutional interpretation embraced by each of these courts, roughly half a century apart. I could, of course, discuss many, many more decisions than these 8, but time is limited, and these 8 decisions are examples of my overall analysis. Now, Chief Justice Earl Warren retired from the Supreme Court in June of 1969, marking the end of the Warren Court. Before Warren joined the court, school districts in 17 states required black school children to go to different schools from white children. In 27 states, it was illegal for a black person to marry a white person. Every state in the nation violated the principle of one person, one vote. Government officials could sue their critics for ruinous damages for inaccurate statements about them, even if the critics acted in good faith. Married couples could be denied the right to use contraception. Public school teachers led their classes in overtly religious prayers. Police officers could interrogate suspects without telling them of their rights. And criminal defendants who could not afford a lawyer had no right to a public defender, and on and on and on. The justices of the Warren Court had a profound vision of the role that the Supreme Court should play in American democracy. Today, especially, it is important to see that the often vitriolic criticisms of the Warren Court were wrong then, and they are wrong today. Since 1969, the Supreme Court has become ever more conservative. We've moved over the years from reasonably conservative Republican-appointed justices like Harry Blackmun, Lewis Powell, John Paul Stevens, Anthony Kennedy, David Souter, and Sandra Day O'Connor, to a court now including such rigidly conservative justices as Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, and John Roberts. Conservatives today insist that they alone are truly committed to the rule of law, that the decisions of the Warren Court were the illegitimate product of the justices' political perspectives. All of this, I submit, is wrong. The Warren Court's decisions, unlike, it should be said, many of the decisions of the increasingly conservative courts that have followed it, were principled, lawful, and consistent with the spirit and fundamental values of our Constitution. The Warren Court's vision at its core was deeply democratic. The Warren Court defined its role as acting when American democracy had failed, when certain groups were marginalized or excluded from the political process, when those groups were discriminated against, and when those in power manipulated the electoral process to perpetuate their own authority. The Warren Court protected African Americans, especially in the Jim Crow South. It protected the rights of political dissenters, religious minorities, and persons accused of crime. It addressed the failures in our democracy, and it stepped in to ensure fairness and equality in our legal and political systems. That is why the Warren Court's decisions have held up over time. Leading figures in the conservative movement have adopted, in name at least, an approach to the constitutional that they call originalism. Originalism has many variants, but the essential idea is that judges, in interpreting the Constitution, should adhere to what they regard as the specific intentions of those who adopted the particular constitutional provision in issue. Originalism conveys a sense of rigor, and the conservative embrace of originalism has fed into the notion that only conservative justices do real law, and that the Warren Court justices were unprincipled activists who simply enforced their own political preferences. In fact, though, originalism is not rigorous at all. It is all too easy for originalism to serve as rhetorical garb for conclusions that are reached for other reasons. Justices with strong personal and political opinions about such issues as gun rights, religion, affirmative action, abortion, voting rights, campaign spending, and so on, simply convince themselves that the framers of the Constitution agreed with them. To be clear, if originalism means adhering to the ideals that the framers embraced, ruled by the people, individual dignity, equality, then no one could object to originalism. And it was the Warren Court that promoted those originalist ideals in a way that no court before or since has ever done. Now, to understand why I say this, it's useful to go back to the original understanding of the framers. When the Constitution was first drafted, James Madison, perhaps the most important of the framers, did not believe that a Bill of Rights would serve any purpose. He believed that political majorities would interpret those rights in any way that suited their own self-interest, and that guaranteeing such rights in the Constitution would therefore lead only to cynicism and disillusion. On December 20th, 1787, Thomas Jefferson, who was then serving as our minister to Paris, wrote to Madison that after reviewing the proposed Constitution, he regretted, quote, the omission of a Bill of Rights. In response, Madison expressed his doubts that a Bill of Rights would provide any meaningful check on the passions of political majorities. He maintained that in practical effect, such constitutional guarantees would be mere, quote, parchment barriers. What use, he asked, can a Bill of Rights serve in a majoritarian government? Jefferson's answer to Madison was clear. The courts, he said, can ensure that the Bill of Rights is effective. Your thoughts on the subject of the Declaration of Rights, he told Madison, fail to address one consideration, which, he said, has great weight with me, the legal check which it puts into the hands of the judiciary. This is a body which, if rendered independent, merits great confidence for their ability to protect the most fundamental values of our nation. This exchange helped persuade Madison, and on June 8, 1789, he proposed a Bill of Rights to the House of Representatives. Echoing Jefferson's letter, Madison said that if these rights are, quote, incorporated into the Constitution, independent tribunals of justice will consider themselves the guardians of those rights. They will be an impenetrable bulwark against every assumption of power in the legislative or executive. They will be naturally led to resist every encroachment upon those rights guaranteed in the Constitution. It was this special responsibility for making our constitutional rights a reality, rather than, in Madison's words, a mere parchment barrier, that animated the Warren Court's decisions throughout the 16 years of its existence. Now, in the next part of my talk, I will illustrate my claims about the Warren Court by briefly examining 4 of its most important and most controversial decisions. I'll explain what the world was like before these decisions, what the justices and the decisions did, and why they were, in my view, correct. The Brown v. Board of Education is, without question, one of the most important Supreme Court decisions in history. Brown, which was decided by a unanimous court in May of 1954, held that the Equal Protection Clause of the 14th Amendment forbids racial segregation in public schools. Brown was the centerpiece of the Warren Court's most important effort, its attack on Jim Crow segregation in the South. More than any other decision, Brown exemplified the Warren Court's vision of our Constitution. In 1896, in Plessy versus Ferguson, a decision that is now as infamous as Brown is iconic, upheld the Louisiana statute that required railroads to provide separate but equal train cars for black and white passengers. From the late 19th century to the middle of the 20th century, segregation was a way of life, particularly in the South. Public transportation, public parks, public beaches, public cemeteries, restaurants, water fountains, bathrooms, and public schools were all rigidly segregated. After World War II, some of that regime began to erode, but segregation still prevailed throughout the South. Public grade schools, especially, were the core of white supremacy. They remained entirely segregated, not just in the Deep South, but in the border states and in the District of Columbia as well. The cases that became Brown v. Board of Education were the culmination of a decades-long litigation campaign by lawyers associated with the NAACP. Earl Warren, the former governor of California, who had just been appointed Chief Justice by President Dwight Eisenhower, both of whom were Republicans, is often credited with having brought about a unanimous decision in Brown. Warren's opinion for the court squarely rejected the doctrine of separate but equal. Separate educational facilities, the court held, are inherently unequal. Warren's opinion emphasized the harm that segregated schools inflicted upon black children. Racial segregation of public schools, he wrote, quote, may affect their hearts and minds in a way unlikely ever to be undone. Central to the Warren Court's approach in Brown was a now famous footnote that the court in 1938 had included in its opinion in United States v. Caroline Products. Footnote 4 in that opinion, which was written by Chief Justice Harlan Fiske Stone, no relation to me, declared that, quote, legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation must be subjected to more exacting judicial scrutiny, and that prejudice against discrete and insular minorities calls for a more searching judicial scrutiny. As evidenced by Brown, this was the vision that the Warren Court embraced. This vision gave the court a role that was consistent with a commitment to democracy and equality, and that enabled the court to insist that democracy must operate in a fair and open manner. In that way, Brown set the stage for much of what the Warren Court did later, and it helped define a principled role for the Supreme Court to play in American government. Brown illustrates the genius of our constitutional system. Constitutional principles are not frozen in time. They evolve as society changes and as experience informs our understandings. The framers of the 14th Amendment did not believe they were outlawing school segregation, but they did have a vision of equality, and the Warren Court courageously carried forward that vision and adapted it for our time. The second case of the Warren Court I'll mention is Engel v. Vitale. On June 25th, 1962, the Warren Court handed down one of the Supreme Court's most controversial decisions ever. In Engel, the Warren Court held that the First Amendment's Establishment Clause forbids a public school to require school prayer at the start of each day. 79% of Americans disapproved of the decision, which generated fierce condemnation. School prayer and Bible reading in public schools first became common in the United States during the wave of religious fervor known as the Second Great Awakening, which swept across the nation in the early 19th century. Over the next half century, with increasing immigration, especially from Catholics and Jews, public schools moved ever more aggressively towards inculcating Protestant beliefs into the educational setting. During the 20th century, conflict over school prayer and Bible reading continued to divide communities. In 1954, at the height of the Cold War, which increased the nation's commitment to religion in public life because it was portrayed as a struggle against godless communism, President Eisenhower declared that without God, there could be no American way of life. And Congress, for the first time, added the words "under God" to the nation's Pledge of Allegiance. In Engel, the Board of Education of New Hyde Park, New York, like most other school districts across the nation, directed school principals to have a prayer said aloud by each class at the beginning of each school day. In 1962, the Warren Court held the practice of school prayer unconstitutional. Justice Hugo Black delivered the opinion of the court. Black explained that the state's use of this prayer in the public school system breaches the constitutional wall of separation between church and state. This was so, he explained, because, quote, the constitutional prohibition against laws respecting an establishment of religion must at least mean that in this country it is no part of the business of government to compose official prayers for any group of the American people to recite as part of the religious program carried on by the government. As with Brown, the reaction to Engel was fierce. The Reverend Billy Graham declared that he was shocked. And Congressman George Andrews of Alabama raged that, quote, first they put Negroes in the schools, and now they've driven God out. Despite the widespread and often furious criticism of Engel, the Warren Court did not back down. And at least for the moment, it still remains good law, and was reaffirmed, by the way, by both the Berger and Rehnquist courts. With more recent changes in the makeup of the Supreme Court today, though, it remains to be seen whether the current justices will continue to honor those precedents. New York Times versus Sullivan is one of the Supreme Court's most important decisions on the meaning of the First Amendment. Like many of the Warren Court's decisions, it arose out of the battle for civil rights. On March 29, 1960, the New York Times ran a full-page advertisement titled Heed Their Rising Voices, which was paid for by the Committee to Defend Martin Luther King. The goal of the advertisement was to raise funds for the legal defense of King, who was then being criminally prosecuted in the state of Alabama. The advertisement, which was successful in raising money, described actions that had been taken against civil rights protesters by local authorities. Some of these actions were described inaccurately in the advertisement. Referring to the Alabama State Police, for example, the advertisement stated that, quote, they arrested Dr. King 7 times, when in fact they'd arrested him 4 times. In response to the advertisement, L.B. Sullivan, the Commissioner of Public Affairs of Montgomery, Alabama, who, by the way, was not even mentioned in the advertisement, filed a libel action against the New York Times and several of the African-American clergymen who had signed the advertisement. The Alabama courts applied the traditional common law standard for libel, under which a speaker who made a defamatory statement about an individual was automatically liable for damages unless the speaker could prove that the statement was true. Applying the standard, the Alabama jury awarded Sullivan a huge damage award, and the Alabama Supreme Court affirmed the judgment. Now, as background to the court's decision in Sullivan, it's helpful to understand that in response to the Warren Court's decision in Brown, Southern officials routinely used libel actions as a way to drive Northern newspapers away from covering Southern efforts to suppress the movement for civil rights. It was against this background that the Warren Court considered the issue of libel in the First Amendment. The court unanimously reversed the lower court decision and fundamentally redefined the relationship between libel of public officials and the First Amendment. In his opinion for the court, Justice William Brennan observed that, quote, we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Brennan then observed that erroneous statement is inevitable in free debate, and that such speech must therefore be protected if the freedoms of expression are to have the breathing space that they need to survive. The defense of truth, Brennan explained, is inadequate to protect a robust freedom of speech and of the press, because a rule compelling the critic of official conduct to guarantee the truth of all his factual assertions and to do so on pain of libel judgments of extraordinary amounts leads to dangerous self-censorship. The Warren Court thus concluded that the First Amendment prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he can prove both that the statement was false and that it was made by the speaker either with knowledge that it was false or with reckless disregard for whether it was false or not. The court's opinion in Sullivan has been lauded as one of the great opinions of American constitutional law, and is perhaps the most important opinion of the court in the realm of freedom of speech. As the renowned legal philosopher Alexander Micheljon famously declared, Sullivan was, quote, an occasion for dancing in the streets. Against that background, it is more than a little unsettling that Justices Clarence Thomas and Neil Gorsuch have now called upon the court to overrule Sullivan. The story of how we got to one person, one vote became an established constitutional principle is in many ways a quintessential Warren Court story. The decisions establishing that rule reflected the Warren Court's deep commitment to democracy and equality. And those decisions were consistent with, and arguably, in fact, demanded by, the principle that courts should step in when the democratic process cannot correct itself. The one person, one vote cases, like other Warren Court decisions, were revolutionary, but they also had deep roots in American law. The reapportionment decisions, as they are known, responded to a serious threat to democratic government. In the middle of the 20th century, in many states, a small minority of the population was able to elect a majority of the state legislature. In particular, urban districts with many times the population of rural districts were represented by the same number of legislators as the rural districts. The Alabama state legislature, which was at issue in Reynolds v. Sims, was an example of these pathologies. Bullock County, with a population of only 13,000, was allocated 2 seats in the Alabama legislature, whereas Mobile County, with a population of 314,000, or 25 times as many people, was allocated only 3 seats. This state of affairs was attributable to 2 things: the migration of Americans from rural areas to cities in the first half of the 20th century, and the unwillingness of state legislators to redraw district lines in order not to district themselves out of a job. The democratic process could not solve the problem because rural legislators, acting out of their own and their constituent self-interest, refused to redraw the lines themselves. In Reynolds, decided in 1964, the Warren Court, in an opinion by Chief Justice Warren, held that, quote, the Equal Protection Clause requires that state legislative districts must be drawn in such a way as to reflect the principle of one person, one vote. Not surprisingly, Reynolds was at first very controversial. Indeed, a bill stripping the Supreme Court of jurisdiction over reapportionment cases passed in the House of Representatives, but failed in the Senate. Once the states began to comply with the court's requirements, though, the principles recognized by the Warren Court in Reynolds became rapidly embedded in the national sense of democratic values. The court in Reynolds declared that, quote, the right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any unwarranted restrictions on that right strike at the heart of democratic government. This principle, referring to the right to vote, did more than condemn malapportioned legislators. It established, as the court said in Reynolds, that, quote, any infringement of the right of citizens to vote must be carefully scrutinized, and that at any time a state treats people unequally with respect to their right to vote, the state must show an especially strong justification for its action. The Warren Court's decisions on voting embraced a principle of equality and of democracy that was essential to our nation, and it did so in a way that was clearly consistent with the appropriate, indeed the essential role of the judiciary in a democratic society. As these 4 decisions illustrate, the Warren Court transformed American constitutional law in fundamental ways and gave meaning to our nation's constitutional commitment to such core values as equality, freedom of speech, freedom of religion, and democracy. In so doing, the justices of the Warren Court lived up to the highest responsibilities of the judiciary in our constitutional form of government. They protected the rights of those who were most vulnerable, and they protected and reinforced the most central tenets of our democracy. They did what justices of our Supreme Court were supposed to do, and what our framers intended. And they did it courageously, in the face of often furious criticism from those who benefited from the world as it was before the Warren Court entered the picture. An interesting question is how might constitutional law have evolved over the past half-century if justices with the same vision of the Constitution as the justices of the Warren Court had remained in the majority. But of course, that is not the way it turned out. To the contrary, Republican presidents have appointed 15 of the last 20 justices, even though Republican presidential candidates have won the popular vote in only 5 of those 13 elections. And they've increasingly done so intentionally to politicize the Supreme Court. So that now brings me to the Roberts Court. As will become evident, in my view, the Roberts Court over time has not only abandoned the Warren Court's fundamental approach to constitutional interpretation, but it has increasingly replaced it with an often unprincipled and all too partisan approach to its most fundamental responsibilities. I say this not just because I disagree with some of the Roberts Court's opinions, but also because I believe that those decisions would be shocking to people like Thomas Jefferson and James Madison, not because in the world that they lived in, they would necessarily have reached different outcomes, but because in the world that we live in today, they would have been appalled at how their vision of the judicial review has been completely distorted. The central thesis of conservative scholars, lawyers, and judges in recent decades is that the Constitution should be interpreted in a manner that is true to the specific understandings of those who drafted and ratified those provisions. This view, unlike the view of Jefferson and Madison, never played a role in debates over constitutional interpretation until the late 1970s, when it was embraced in particular by Robert Bork, Antonin Scalia, and the Federalist Society. Before then, pretty much everyone understood that given the highly ambiguous language of the provisions of the Constitution, it would be largely pointless to imagine that there was any definitive original understanding of those provisions that could be clearly and definitively identified. In recent decades, though, as the court has become ever more conservative, this has increasingly become a purported, but all too disingenuous, rationale for the justices' decisions. As with my discussion of the Warren Court, I will discuss 4 important decisions of the Roberts Court, although, as with the Warren Court, I regard these decisions as merely illustrative of the Roberts Court's approach to constitutional interpretation. In particular, I will discuss the Roberts Court's decisions in 4 fundamentally important areas of constitutional law: campaign finance, guns, abortion, and affirmative action. Let me begin with the Roberts Court's dramatic 2010 decision in Citizens United v. Federal Elections Commission. Citizens United, the court, in a 5-4 decision, with only Republican-appointed justices in the majority, overturned centuries-old campaign finance restrictions designed to ensure a fair and principled electoral process, and ultimately enabled corporations and billionaires to spend unlimited funds to manipulate both the electoral process and the behavior of elected officials. In short, the Republican-appointed justices who decided Citizens United held for the first time in American history that limiting such spending violated the First Amendment's guarantee of freedom of speech. Ironically, there is nothing in the text of the Constitution or in the records of the Constitutional Convention that provides any hint that the framers thought that the Constitution was meant to extend its constitutional protections to entities like corporations. Although the Supreme Court in the late 19th and early 20th centuries began recognizing the property rights of corporations in cases like Lochner v. New York, it consistently and emphatically rejected arguments that corporations had other fundamental rights protected by the Constitution. As the court declared in 1907, referring to corporations, quote, "The fundamental rights guaranteed by the 14th Amendment are the rights of natural, not artificial persons." Moreover, in 1990, in Austin v. Michigan Chamber of Commerce, a 6-member majority, including even Chief Justice William Rehnquist, upheld the constitutionality of a state law that prohibited corporations from attempting to influence elections by using their general treasury funds. The court explained that, in light of the unique legal and economic characteristics of the corporate entity, corporations must have more limited rights to spend money on electoral politics than ordinary people. 13 years later, in 2003, the court in McConnell versus Federal Election Commission upheld the constitutionality of the bipartisan McCain-Feingold Campaign Reform Act of 2002, which had bipartisan support in Congress and was signed into law by President George W. Bush. In their opinion for the court, Justices John Paul Stevens and Sandra Day O'Connor, both appointed by Republican presidents, invoked the long history of government restrictions on corporations in the realm of campaign finance, and upheld the constitutionality of the law because it was justified by the government's important interest in preventing the corruption of the electoral process threatened by large financial contributions. 3 years later, though, Justice O'Connor stepped down from the court and was replaced by Samuel Alito. Shortly thereafter, the now 5-member conservative Republican majority in Citizens United, including Roberts, Scalia, Kennedy, Thomas, and Alito, overruled both Austin and McConnell, as well as a century of Supreme Court precedents, and held that corporations have a First Amendment right to spend limitless general treasury funds, either in favor of or against candidates for public office. As Justice John Paul Stevens observed in his dissenting opinion, the majority in Citizens United ignored the dangers of the corporate form and opened the door to the potentially distorting influence on the democratic process. Corporations, he observed, are not we the people, for whom the Constitution was established. In the years since then, the Roberts Court, with the support of only Republican-appointed justices, has vastly limited the ability of all levels of government, state, federal, and local, to constrain the highly distorting effects of corporations and extraordinarily wealthy individuals on our democratic process, which, not surprisingly, has almost always benefited Republican candidates. Imagine, for example, that in a political debate in an election for mayor, time was allotted to each candidate based upon the amount of money that they and their supporters paid to the organizers of the debate. Thus, some candidates would be allotted 40 minutes, while others would be allotted only 5. Is that really consistent with the goals and values of our democracy, with what the framers of our Constitution, including Jefferson and Madison, ever intended? So much, once again, for original understanding. Let me now turn to the issue of guns and the Second Amendment. The Second Amendment provides that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Looking to the text, one question is, what does it mean? Does it mean that all persons in our nation have an inviolable constitutional right to purchase, obtain, own, and carry in public any handgun, rifle, machine gun, etc., that they like? Or does it mean something less than that? Like almost all rights guaranteed by the Constitution, language that seems absolute on its face, whether it is freedom of speech, freedom of religion, equal protection of the laws, and so on, is never interpreted literally. Rather, the Supreme Court quite sensibly always holds that such language must be understood in terms of the broader concerns and values of the particular provision at issue. Moreover, the text of the Second Amendment seems explicitly more limited than those other provisions, because it includes in the text a specific reason for protecting the right: the need to have, quote, a well-regulated militia. One would think that that language defines the original meaning of the Second Amendment. The Supreme Court first addressed the meaning of the Second Amendment in 1939 in the case of United States versus Miller. In Miller, the court considered the constitutionality of the National Firearms Act, which, among other things, made it unlawful for any person to transport in interstate commerce a 12-gauge shotgun without first registering it with the federal government. In a unanimous decision, the court rejected the argument that the act violated the Second Amendment. In an opinion by Justice McReynolds, the court explained that Congress could regulate a sawed-off shotgun because the evidence did not suggest that the shotgun, and I quote, has some reasonable relationship to the preservation or efficiency of a well-regulated militia. In short, the court held that the framers enacted the Second Amendment not to guarantee an independent right of the individual, but to ensure the effectiveness of the militia, in part because at the time that the Second Amendment was adopted, all male citizens of a certain age were expected to be prepared to join the militia, if necessary, bearing arms supplied by themselves. This precedent, holding the Second Amendment did not protect any distinct constitutional right of the individual, stood for nearly 70 years, until 2008, when the Roberts Court revisited the issue in the case of District of Columbia versus Heller. The plaintiff in Heller challenged the constitutionality of a Washington, D.C. law that, among other things, made it a crime for any person to carry an unregistered firearm in public. In a 5-4 decision, in an opinion by Justice Antonin Scalia, joined by the 4 other Republican-appointed justices, and with Justices Stevens, Souter, Ginsburg, and Breyer dissenting, the court held that the Second Amendment protects the right of individuals to possess firearms wholly unconnected with any service in the militia, including handguns, rifles, shotguns, and machine guns, and to use those firearms for any lawful purpose. Predictably, the justices strongly disagreed about the original meaning of the Second Amendment and about the relevance of the reference in the text to a well-regulated militia being necessary to the security of a free state. In his majority opinion, Justice Scalia insisted that that phrase did not in any way limit the right to own and to carry guns purportedly guaranteed by the Second Amendment. What had changed most from Miller to Heller were two fundamental things. First, the majority of the justices had moved sharply to the right over that time. And second, the National Rifle Association had become a powerful political force in the nation and had a huge impact on the views of the Republican Party, thus no doubt affecting the ideology of the justices in the majority in Heller. In the years since Heller, the Roberts Court has decided several additional cases concerning the meaning of the Second Amendment. Most recently, in New York State Rifle and Pistol Association v. Beermann, decided in 2022, the court considered the constitutionality of a New York law that prohibited any person to carry a handgun in public unless he could demonstrate that he had a special need for self-protection, such as evidence of threats, attacks against him, or other danger to his personal security. In striking down the constitutionality of this law, the court, in a 6-3 decision, with a majority opinion written by Justice Clarence Thomas and joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett, held that the law was unconstitutional because, rejecting the reasoning of most lower courts since Heller, a law regulating firearms cannot be held to violate the Second Amendment, even if it furthers an important government interest, unless, and I quote, the challenged regulation is consistent with the nation's historical tradition. Changed circumstances, in other words, are irrelevant. Thus, because the challenged New York law was not commonly used throughout history, it necessarily violates the Second Amendment, despite urbanization and enormous changes in the nature of firearms over the years. Not surprisingly, Justices Breyer, Sotomayor, and Kagan dissented. This term, the court will decide a major gun rights case challenging the constitutionality of a federal law prohibiting the possession of guns by individuals who are subject to domestic violence restraining orders. We shall see. By the way, in no small part, because of the Roberts Court's decisions on the Second Amendment, the United States today has 120 guns for every 100 people. That compares with Canada, with 30 guns per 100 people, France and Germany with 20 guns per 100 people, Italy with 14 guns per 100 people, Mexico with 13 guns per 100, Russia with 12 per 100, and Israel with 6 per 100, which the United States now has 120 guns per 100. Indeed, there are now 400 million unregistered guns in the United States, and the percentage of Americans murdered each year by firearms is 22 times higher than the rate of such murders anywhere in Europe. Surely that's what the framers intended. Let me now turn to the issue of abortion. One of the most important Supreme Court decisions in the 20th century was the court's 1973 decision in Roe versus Wade, which of course was overruled by the Roberts Court in 2022, almost half a century later. Let me emphasize at the outset that Roe was not a Warren Court decision, but it was a decision of the Burger Court. The story of how we got to Roe, like the story of how we got to Brown, is important to remember, for it gives both content and context to the decisions in Roe and Dobbs. So let's begin at the beginning. At the time our Constitution was adopted, abortion was often relied upon by women to avoid the consequences of unwanted births. In that era, contrary to what many people today assume, abortion before quickening, that is, before the point at which the woman could feel movement, usually at around 4.5 months, abortion was perfectly legal in every state in the nation. Moreover, even abortion after quickening was almost never punished. Indeed, this had been the state of the law at least as far back as the ancient Greeks. Although in the Middle Ages the church condemned abortion as a sin, the law did not treat abortion as a crime. To the contrary, those who did not share the faith were free to do as they wished. For most families, abortion was seen as a critical way of managing family size. Indeed, in the early 19th century, approximately 20% of all pregnancies in the United States ended in legal abortion. The general acceptance of abortion began to change, however, during the 19th century, Two factors in particular contributed to this shift. First, religious perspectives on abortion began to change during the evangelical explosion of the Second Great Awakening, when evangelicals began to preach that a separate, distinct, and precious life came into being at the very moment of conception. Second, medical professionals in this era increasingly came to the view, based partly on religion and partly on half-baked science, that human life begins at conception. In the 1850s, for example, the Boston doctor and religious moralist Horatio Storer emphatically rejected the notion that a woman should be able to decide this question for herself because he maintained during pregnancy a woman's mind is prone to derangement. Over the next several decades, religious moralists launched an aggressive campaign to rid the nation not only of abortion, but of contraception as well. As the leading voices of this movement, such as Anthony Comstock, explained, the sole purpose of women is to produce children, and women must therefore remain within their God-given sphere. As a result of this campaign and a complete reversal of the world of the framers, every state, by the end of the 19th century, had enacted legislation prohibiting the distribution of any product designed for the purposes of contraception, and every state had enacted legislation prohibiting abortion at any stage of pregnancy, unless a doctor certified that the abortion was necessary to save the life of the woman. Thus, for the first time in our nation's history, and in Western civilization's history, abortion was unlawful even before quickening, and women who sought abortions were now themselves subject to criminal prosecution. But despite the threat of criminal sanctions and the preaching of religious moralists, women in the late 19th century continued to seek abortions in record numbers. Indeed, by the turn of the 20th century, approximately 2 million women had illegal abortions each year, and almost a third of all pregnancies ended in abortion. But now, for the first time in history, these abortions had to be performed in secret and unsafe circumstances, and by much reliable practitioners than in the past, resulting in many more serious injuries and deaths. For the 1950s, with improvements in contraception, which was now increasingly but not universally legal, the number of unwanted pregnancies gradually declined. But even then, approximately 1 million women each year resorted to illegal abortions. The vast majority of these women continued to turn either to self-induced abortion or to the dark and often terrifying world of back alley abortions. In addition to those women who died in the course of these secret and illegal abortions, many thousands more each year suffered serious illness or injury. In the 1960s, though, the rising voice of the women's movement began to shape public discourse on abortion, arguing that, quote, there is no freedom, no equality possible for women until we assert and demand the control over our own bodies, over our own reproductive process. As these arguments moved to the forefront of national debate, the law began to change, and several states now once again legalized abortion. But the fierce opponents of abortion rights and of the rights of women more generally, such as the moral majority, quickly mobilized their forces and effectively shut down any further political progress, despite the clear majority support for legalizing abortion. Faced with this sudden paralysis in the legislative arena, pro-choice advocates began for the first time to challenge the constitutionality of anti-abortion laws in the courts. And in a series of lower court decisions, judges held that state anti-abortion laws were unconstitutional because, as a Republican-appointed federal judge in the South explained, such laws trespass, quote, unjustifiably on the personal privacy and liberty of its female citizens in violation of the Constitution. Soon thereafter, the Supreme Court announced that it would hear the case of Roe versus Wade. Now, many Americans today think of Roe as a radical left-wing decision, but that was not at all the view at the time. To the contrary, by 1973, a substantial majority of Americans supported the right of a woman to terminate an unwanted pregnancy. Although the Constitution does not expressly mention a right to abortion, the Supreme Court has long understood that the framers of our Constitution did not intend to limit the rights of Americans to only those rights that are expressly guaranteed in the Constitution. To the contrary, the court, invoking the Ninth Amendment, the Due Process Clause's guarantee of the right to life, liberty, and property, and the implied right to privacy, among others, had often recognized constitutional rights that were not expressly mentioned in the Constitution, including, for example, the right not to be sterilized, the right to use contraception, the right to travel across state lines, the right to marry, and the right to raise one's own children. In an overwhelming 7-2 decision, the Supreme Court in Roe held that the Constitution did indeed guarantee a woman's right to decide for herself whether or not to bear a child. Strikingly, 5 of the 6 justices appointed by Republican presidents, including even Chief Justice Warren Burger, joined the decision. Indeed, without their support, Roe would have come out the other way. That speaks volumes about the mainstream nature of the decision at the time. The plain and simple fact is that at the time Roe was decided, the justices did not view the abortion issue as posing a particularly divisive or controversial ideological question. I can personally attest to this because I was a law clerk for Justice William Brennan when Roe v. Wade was decided, so I saw it all firsthand. Of course, as we know, Roe eventually emerged into a bitterly divisive issue, and this did not happen until the end of the decade, as the culture wars exploded over such issues as the Equal Rights Amendment, gay rights, sexual expression, and women's liberation, thus inflaming political and especially religious conservatives into a single unified political movement. Indeed, by the summer of 1980, Republican Party leaders were treating Jerry Falwell, the head of the moral majority, more than any other religious figure in American history, like the leader of a powerful political constituency. And in his pursuit of the presidency, Ronald Reagan promised to appoint pro-life judges at all levels of the judiciary, thus ushering in a historic era of judicial nominations shaped in no small part by religious conceptions of constitutional law. In the years after 1980, a succession of Republican presidents sought openly to appoint Supreme Court justices who would vote to overrule Roe. Interestingly, though, 3 of those justices, Sandra Day O'Connor, Anthony Kennedy, and David Souter, disappointed those who appointed them, demonstrating both a respect for precedent and an understanding of the fundamental right at issue in Roe. O'Connor, Kennedy, and Souter consistently reaffirmed Roe, despite repeated efforts to overturn the decision. Having learned this lesson, though, Republican presidents, from Reagan to Trump, grew ever more determined not to replicate this mistake. And with the Republican appointments of Justices Clarence Thomas, John Roberts, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all of whom were chosen in no small part because of their deeply embedded anti-abortion views, the anti-abortionists finally achieved their goal of overruling Roe. In the United States, before the decision in Dobbs, 30% of all women had at least one legal abortion during their lives. Just under 1 million women had legal abortions annually. Roe is deeply grounded in the justices' understanding in 1973 that we as Americans must have the right to make fundamental decisions about our own lives and our own destinies. Roe enabled women to chart their own futures and to control their own bodies. Indeed, it is a long-standing observation that if men could get pregnant, abortion would always have been safe and legal. But with the court's decision in Dobbs, hundreds of thousands of women, mostly poor and minority, will once again be thrown each year back into the dark and dangerous world of illegal abortions. So what was the reasoning of Justice Samuel Alito's 100-page opinion? The first challenge he faced, of course, was the doctrine of stare decisis. But Alito gave little of any weight to this long-standing principle of judicial decision-making. It's noteworthy, by the way, that in the vast majority of its decisions, in which the Supreme Court has overruled a prior decision, it has done so, as in Brown, Engel, Sullivan, Reynolds, and many, many others, in order to expand the rights rather than to contract the rights of Americans. In order to make his case in Dobbs, Alito argued that Roe was fundamentally wrong, because at the time the 14th Amendment was adopted, a majority of states, for the reasons I set out earlier, had already made abortion a crime. Thus, applying a so-called originalist view, Alito insisted that Roe was wrong because those who adopted the 14th Amendment did not at the time affirmatively intend that amendment to hold laws restricting abortion unconstitutional. That clearly seems right. The framers of the 14th Amendment were not thinking about abortion in 1868. But the problem with this way of interpreting the Constitution, as I noted earlier, is that it is inconsistent with the more general goals and values of those who adopted these broad and open-ended provisions. What the framers of the 14th Amendment were doing, as the Burger Court understood in Roe, was embracing within the Constitution the principles that they knew would have to be interpreted and applied over the course of centuries. Although Alito's originalist view seems credible to some conservative lawyers, judges, and academics, it has never carried the day in the profession of law, in academia, or even in the Supreme Court. problem with originalism is that it is not originalist. It embraces an approach to constitutional interpretation that the framers themselves never intended or even imagined. But that is the core of Alito's argument. He goes on and on to berate and insult Justice Harry Blackmun for writing the opinion in Roe, as well as the other 6 justices who joined the majority. In the end, though, Alito's opinion and the court's decision is not based on any principled approach to constitutional law. It is instead a personally driven decision designed to further the political and religious views of the justices in the majority and of those who appointed them. Now, I'd like to make one final point about this. From 1973 to the present, among the justices not on the court at the time of Dobbs, 10 Republican-appointed justices supported the decision in Roe, and only 2, Scalia and Rehnquist, opposed it. In the current court, Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett all voted to overrule Roe v. Wade. That is the product not of principled law, but of politics, determining the makeup of our Supreme Court and the meaning of our Constitution. Let me turn now to the final case I'll be discussing, and that involves the issue of affirmative action, and the Roberts Court's 6-3 decision last term, holding that affirmative action violates the Equal Protection Clause of the 14th Amendment. In effect, the 6 Roberts Court's Republican-appointed justices, overruling 45 years of precedent, held in the UNC case that the Equal Protection Clause prohibits the government to take race into account, even for the noblest of reasons. In the decades following Brown, the nation discovered that not discriminating against Black Americans was not enough to mitigate centuries of severe injustice, a legacy of discrimination, as Justice Thurgood Marshall called it. More than 3 centuries of slavery, segregation, racial violence, and rampant discrimination helped shape a toxic national culture designed to ensure that Black Americans were, quote, kept down. By 1950, Black Americans accounted for 10% of the population. The United States Congress contained only 2 Black congressmen, no Black senators, no Black person served as a governor, and no major U.S. city was led by a Black mayor. Employment opportunities for Black Americans were likewise severely limited. The overwhelming majority of Black Americans at that time worked in low-paying manual or agricultural jobs. As the injustice of racial discrimination became ever more evident, in a televised speech in 1963, President John F. Kennedy declared that the time had come for the nation to, quote, fulfill its promise of racial equality. After the assassination of President Kennedy, President Lyndon Johnson propelled the 1964 Civil Rights Act through Congress. Understanding that Black economic equality was as severe as Black political inequality, Johnson launched the social welfare programs he called the Great Society. 2 years later, following a bloody riot in Selma, Alabama, Johnson declared that, quote, it is not just Negroes, but really all of us who must overcome the crippling legacy of bigotry and injustice. Soon thereafter, he declared that, quote, freedom is not enough. You do not wipe away the scars of centuries by saying, now you are free to go where you want and to do as you desire. You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, you are now free to compete with all the others. And still justly, he said, believe that you have been treated fairly. Equal opportunity is essential, he said, but not enough, not enough. Equal treatment in the present, he concluded, could not redress the deeply continuing effects of severe and often violent racial discrimination. By the late 1960s, a new wave of controversy arose in higher education. Admissions departments of colleges and universities emerged as the next battleground over racial justice, with their policies of affirmative action that were intended to address the consequences and continuing effects of our nation's historic racial discrimination. The case that would establish the framework for evaluating the constitutionality of affirmative action for decades to come was the Supreme Court's 1978 decision in University of California versus Bakke. Bakke, a white man who was not admitted to the University of California Medical School, maintained that the institution's affirmative action program was unconstitutional. 4 of the justices voted to uphold the constitutionality of the program on the ground that it is constitutionally permissible for the government to take race into account to remedy the disadvantages imposed on minorities by past and present racial prejudice and violence. 4 other justices avoided the constitutional question entirely. The decisive opinion in Bakke was written by Justice Lewis Powell, one of the 4 recent Nixon appointees. Powell voted to invalidate the UC Davis's program because it used a fixed racial quota to guarantee a predetermined minimum number of places for minority applicants. But he rejected the notion that any consideration of race in university admissions is unconstitutional. In Powell's view, race could be considered as one of several factors in college admissions policies, because such programs were justified by the need for educational diversity. Justice William Brennan, joined by Justices White, Marshall, and Blackmun, wrote separately, noting that, quote, government may constitutionally take race into account when it acts not to demean or insult a racial group, but to remedy severe historical disadvantages cast on racial minorities in past and present racial prejudice. Despite Justice Powell's hope that his diversity rationale for affirmative action, rather than the rationale of past and present discrimination, would benefit white as well as black students, and therefore would modify the objections of those who opposed affirmative action. Post-Bakke, that resentment was deliberately aroused by affirmative action's foes. President Ronald Reagan, for example, refused to enforce many of the nation's civil rights laws and dismantled many federal affirmative action programs that had been established even by President Richard Nixon. By the decade's end, Reagan had appointed Sandra Day O'Connor, Antonin Scalia, Anthony Kennedy to the Supreme Court, followed in 1991 by President George W. Bush's appointment of Clarence Thomas. Affirmative action was now under serious threat. A quarter century after Bakke, the Supreme Court decided 2 affirmative action cases in 2003 involving the University of Michigan. Given the makeup of the court at the time, when 7 of the 9 justices had been appointed by Republican presidents, many people believed that the court would hold that any consideration of race in this context was a violation of the Constitution. But because Sandra Day O'Connor sought a middle ground and persuaded Justices Stevens and Souter to join her, the court upheld the use of race as one of many factors in making admissions decisions. In the following decades, the Supreme Court consistently upheld the constitutionality of affirmative action programs as long as they were consistent with O'Connor's approach. Last year, though, with the court consisting of 6 deeply conservative Republican-appointed justices, including 3 appointed by Donald Trump, the Roberts Court once again overturned almost half a century of precedent and held that it was per se unconstitutional to take race into account in order to achieve the benefits of diversity or to redress the consequences of centuries of past and continuing racial discrimination. Now, one might have thought that these justices would follow the doctrine of precedent, but of course these were the same justices who a year earlier had overruled the court's decision in Roe. I should note, by the way, that even an originalist interpretation of the 14th Amendment leaves room for factoring in race as an appropriate consideration for rectifying the effects of both past and present racial discrimination. Indeed, at the same time that the framers passed the Equal Protection Clause, they simultaneously passed a long list of race-conscious legislation designed to help ensure that the amendment's promise of equality would be a reality for Black Americans. To cite just one example, in 1866, Congress expressly appropriated money for the purpose of supporting colored women and children. Such explicit references to race in a range of federal and state legislation, enacted at the same time as the 14th Amendment, render it undeniable that in passing that amendment, the framers did not affirmatively intend to foreclose any government reliance on race in order to remedy the egregious past, present, and future effects of racial discrimination. Many Americans are eager to believe that our country has leveled the playing field and delivered equal opportunity to its Black citizens, but wide educational, economic, and social gaps remain. Of course, many Black Americans have made progress, in no small part as a result of affirmative action. But America today remains 2 separate spheres, one Black and the other white. Our society today maintains a broad range of disadvantages for Black Americans in terms of residential segregation, unequal schools, much lower average annual income, much higher risk of being the victims of crime, much lower access to health care, a much higher risk of being imprisoned, and a much greater risk of living in poverty. Today's 6 Republican-appointed justices simply chose to ignore this reality in its decision last term. That decision will do serious damage to our nation's capacity to achieve meaningful racial equality in light of our long and continuing history of racial discrimination. In thinking about the Roberts Courts, by the way, it is worth noting that in the 45 years between Bakke and the present, 8 of the 10 Republican-appointed justices, not now on the court, voted to uphold the constitutionality of affirmative action, but no longer. Unlike the Warren Court, the Roberts Court has a profoundly different understanding of our Constitution. In my view, the Roberts Court completely disregards the fundamental responsibilities that Jefferson and Madison counted on our Supreme Court to fulfill with courage and determination in order to achieve our nation's deepest constitutional aspirations, protecting democracy, liberty, and equality. Thank you.
We have a couple of minutes for a question or two. We need a quick one.
Sorry, I went on too long.
If you have to leave, that's fine. No, that was terrific. We did get started a little bit late, so if anyone has a quick, relatively quick question, Jeff Sylvie in the front here.
I'll ask the question about limiting the court's power. So if there's one way of thinking about how the current court is just a return to old courts. That is, the Warren Court was the unusual court, and the current court is more like a status quo court. I think that's probably wrong because the Warren Court was a progression of courts over time, and the current court is really a reversal of that progression, and so it stands out as unlike all the other courts. But given that, and given the practical realities of, I think, wanting to continue the Warren Court's progression, I wonder if arguing about what the law is or should be, or how what the Constitution means to this court is a lost cause. And I'm wondering what you think, therefore, about the possibility of limiting the court's power through judicial review, stripping judicial review.
So first of all, I would say this court is not a return to prior courts. Prior courts were more passive, more restrained. They were not taking aggressive decisions except in a very few areas that were analogous to what this court is doing. They basically chose to limit the responsibility and authority of the courts, not to exercise it aggressively in a particular political way. In terms of this court changing, I think that it's important to believe in free speech, that even justices on either side who have very strong views can hear thoughtful disagreements. And again, to remember that Warren Burger joined the Roe decision, and that people like Powell and O'Connor and Souter and Stevens voted with the liberals in most of these cases. Now we have a set of justices who are much more defined in what they believe is right. And it'll be much harder to impress upon them why they should think twice about this. But I don't think it's impossible. And I think what's important is saying this out loud and talking about it. And I'm not saying I'm confident that this will happen for all of them or even 2 of them, but I think it's possible. And so I think that's the first remedy or response that one should take, to believe in free speech, to believe that people could be persuaded, and maybe they can. Not all of them are necessarily rock solid in their conservative views. And if you can change 2 of their minds, that would make a significant difference. Institutionally, I don't know that I would be very happy with any of the changes that are suggested. If the idea was to increase the size of the court, so Joe Biden could appoint 4 more justices, that would just be a nightmare, because then as soon as a Republican was elected president, they would add another 4 justices that he would appoint. So I don't think that's going to solve any solution. And I also think we're talking about the long run. These developments occur over decades and even centuries, and therefore stating the views and stating the criticisms and listening to their arguments and addressing them seriously is not an impossible way to address these issues. And also, there will be more appointments down the road. Unfortunately, from my standpoint, all but Thomas are pretty young. But even so, there will be more appointments over the next 10, 15 years. And the Supreme Court and the nation are long stories. So the law can evolve in different ways over time. But I do believe that the Supreme Court, as Madison and Jefferson said, is necessary to play a fundamental role in our democracy. If we did not have that, then the abuse of democracy would be much greater and inevitable. And this may be the best way of trying to put a check on it. And it's not perfect. The other choice is assassination, of course, but I'll put that aside.
Okay, maybe one more quick one. People can leave if they need to, obviously. Anyone? I have one. Go ahead, Ethan. Let Ethan ask.
Sure. So I was curious, like, given that we're now entering into multiple decades of a politically captured Supreme Court, and assuming that one day there are more appointments and that the dynamics of the court will change, how can future courts that are more in line with like the Warren Court style of thinking kind of redirect the country without totally upending the doctrine of stare decisis and preventing our courts from having a backwards looking kind of basis in prior precedent, which, for me, I think is really essential.
Well, that's, of course, one of the main challenges, is that even if you had 20 years from now a court consisting of people nominated by more liberal presidents, what do they then do about these decisions that they don't like? If they don't want to undermine the credibility of the court as an institution, they can't just run amok and overrule all the prior decisions that they think were wrong. On the other hand, this court is doing that. So the question is how you deal with that. But what I worry about is two things. One is I think that this court is doing real harm to the country and to the citizens of this country. And second, I think for the reasons you've discussed, it's doing real harm to the court as an institution of integrity. And I think that's a terrible thing. I think that Jefferson was right, that we need a Supreme Court in a democracy where people are interested in their self-interest. And they're not moral enough across many dimensions to think of other people the way they want themselves to be thought of. And that's one of the key reasons why we have a Supreme Court and a Bill of Rights. And the court has to be doing that if we're going to remain a democracy. So there's no simple answer. It's a great challenge.
I think I'm going to declare us into informal session now. Thank you very much. This was terrific.
Thank you.